Welcome to Virtual Proceedings in the New York and Federal Courts, Lessons Learned and Next Steps, Experience in the People's Courts. As we approach the one-year anniversary of the pivot to remote proceedings across the full range of state and federal courts in New York City, the Council on the Profession and several other city bar committees have convened a working group to gather information on what is taking place, how well it is working for all of the stakeholders, including lawyers, clients, judges, and court staff, and what kinds of best practices can be identified. In order to advance these efforts, the City Bar is presenting 3 webinars with leading lawyers, judges, and court administrators to discuss the conduct of these virtual proceedings, trials, appeals, case conferences, and related proceedings in New York State and federal courts, how they are presently conducted, and what can be learned from current experience. This is the first of the series and focusing on high volume courts. The second will concern complex litigation courts, and the third will be a roundtable on best practices. Our panelists tonight will speak about remote proceedings in the civil, housing, family, and criminal courts, and then there will be a Q&A. The first person to speak is the Honorable Shahabuddin Ali. He's the supervising judge of the New York County Civil Court. He presided over virtual criminal court matters in the Bronx Criminal Court from March to September 2020, prior to his promotion to supervising judge in New York County Civil Court. Since September 2020, Judge Ali has been hearing virtual civil court matters and presided over virtual trials in areas such as no fault, commercial and commercial landlord-tenant, I'm so used to saying L&T, consumer debt, small claims, and general civil matters. Judge Ali will speak to both civil and criminal court remote proceedings. I'm going to start you right here, Judge Ali, and I will introduce the others as their turn comes up.
All right. Thank you, Sarah. Good evening to everyone. Sarah, thank you very much for your kind words of introduction and for the task of moderating this panel. This panel is incredibly relevant and hopefully helpful to everyone. I also want to thank and wish well my fellow panelists, Elizabeth and Lorna, on their presentation. And just so they know, I have a pen and pad ready to copy down all the notes that they're going to share. I also had the privilege of speaking to, before this webinar started, for a few moments, the Honorable Michael Cardozo, who was the Corporation Counsel at the time and hired me in 2004. So I thanked him for that. Because that helped a lot with what we're doing now. It is a very interesting time that we're living in civil court, in all of the courts. Sarah listed all of the different trials or proceedings that I personally have handled while in civil court, and all of our judges handled these matters: no fault, commercial landlord-tenant, general civil, consumer debt, small claims. And that's before you even have your second cup of coffee in the morning. The civil courts of New York City are truly our people's courts. And I don't want to pick a fight amongst my judicial colleagues here about what's the crown jewel of our court system, but I'm going to say now that civil court is our crown jewel of the court system, led by our administrative judge, Anthony Giancarlo. I think that was a world record, Sarah. I think someone already objected to something I'm saying in 15 seconds. It's usually the litigants booing me on the bench. Now I got someone else bombing me. But the interesting part about this is that there is no playbook for how to proceed under a pandemic. It's a once in a lifetime type of event. Hopefully we'll never see this again, or if not, maybe 200 years from now. So a lot of credit, and I'll get into what we do in civil and how the important thing is what we're doing now, and really the lessons learned for the future. But I think what's important for everyone on this call, and I'm looking at the numbers, the participants, it's a very large number, 153 folks here. I think we all agree that the playbook was never written for this. So we are all learning from one another, learning from other courts, taking in inspiration. So a lot of credit, and this had to be done. The turnaround time was very quick, in a matter of months. And when you talk about it and think, well, there was months, but we talk about the history of our court system being hundreds of years old. But then in a matter of 3-4 months, we convert from being an in-person operation to doing it virtually. A tremendous amount of work happened, and this is a tremendous amount of success to continue the important court functionings without sacrificing the work of the courts and without sacrificing the rights of the litigants. So I think a lot of credit has to be given as well to our Chief Judge, Janet DeFiore, Administrative Judge Lawrence Marks, our Deputy Chief, Administrative Judge George Silver, and my Administrative Judge, Anthony Canatero, but also with the other two disciplines that we have, Administrative Judge Smiko Amaker for criminal court, Administrative Judge Jeanette Ruiz for family court, and Gene Schneider, who's the supervising judge for housing. It really takes a community effort to have a lot of what we're doing now happen seamlessly. So in terms of how we're doing it, in civil court, in our courts across our system, we're using Microsoft Teams, right? For many of us, this was not the way court happened. But as our chief judge has charged each of us, we have to reimagine what litigation looks like. We have to reimagine what court looks like. If you take in-person out of play for now, what else can we be doing? Can we start to supplement? Can we start to continue our work of our function of our courts effectively? And that's where a virtual platform comes in. So we use Teams. But what's interesting, and what I hope everyone remembers about this, is that while we're using Microsoft Teams, it is still possible for individuals to phone in to Teams. The way I see it when I preside is, I'd rather have you there versus not there. So if you can sign in with Teams, great. If you need to call in, great. I want to make sure that we have everyone present and that nothing is sacrificed in terms of doing the work. The procedures that are followed in civil court it all starts in the same way across the 5 counties. With the virtual proceedings, now the emphasis with virtual proceedings is to limit the in-person operation for the safety of those working in the courts, for the safety of the court users. So with safety in mind. So we want, as much as possible, encourage the use of this virtual platform, which, by the way, works well. With very few hiccups, but they're expected hiccups. So I was quite surprised with how effectively it could work. The one challenge we have with the virtual proceedings is capturing the data of the individuals who are coming in terms of email addresses, right? That's how you receive links to sign on. You receive them through an email address. It's amazing that. And we'll take 2 buckets. We'll take the pro se litigants, and then we'll take attorneys. Attorneys, sometimes it's hard to capture their email addresses. And now you're probably thinking with attorneys, that would be the easy part. Half of my day, I feel like I'm playing detective, hunting down attorneys' email addresses. So one of the charges for tonight was identify what's happening, maybe a little problem, but what the current solution would be. For attorney emails, maybe it's time for us to redo our notices of appearance where we don't need a fax number anymore. Maybe I don't want to know your fax number because I'm not faxing you something, but maybe I want to know your email address. So it's not a guesswork how to get links there. In New York County Civil Court, links are sent out to parties ASAP. There's no reason to hold on to them. As soon as a case is adjourned and as soon as it's generated, you get it. It's on your calendar. It's a very important date. We get them out right away. With pro se litigants, it's the same thing. We want to make sure that we capture all of the data. So when it comes to a problem that we see on a daily basis, one of the things that we see is, do we have the information necessary to invite individuals to the proceedings? Once they're there in the proceedings, then we have another set of considerations. So if things are at a halt, it's because we don't have good information to send out individuals and invite them to join in. I will tell you, by the way, that Microsoft Teams to court users at this point is the routine daily habit. For the average court user, Microsoft Teams might be this brand new thing. Maybe everyone's used to being on Zoom or Skype. When we send out these links, and this is something I hope everyone here will pass this information along to those who might become court involved. When you receive the link from the courts to join a Microsoft Teams, it also comes with instructions how to get the actual platform onto your device. It could not be any more user-friendly or convenient. The only thing missing is my finger pressing submit on your device. That's the only thing missing. Otherwise, we make it very easy for you because the court system wants you to be involved. I want you to be involved. As a supervising judge, I want everyone to be involved and for the courts and for the decisions to be made on the merits. So that's one, when I was thinking about this presentation, I was thinking about what's the one challenge I have on a daily basis, like a one real challenge, and that is capturing individuals' attention and getting their email addresses. Another thing that we have, now this is the pre-pandemic and while we're in the pandemic, I don't know what we're going to do post-pandemic, but it's calendars, figuring out, do people know what cases they have on? Attorneys, litigants, e-courts, e-law gets that information. Individuals can't come to the courthouse now and look on the wall and see where their what dates there are. We are working in civil court on a system of utilizing or better utilizing our website. And this is all being done under the watchful eye and supportive eye of our administrative judge, Canatero, with better using our email, our website, so that if it, what's key to me is that the users have an independent way of getting information. They should not be dependent on us. We should give everyone their own access and own ways to get information. And for that, I say, we have a website, let's better utilize it. And that's something that we are working on. I'm gonna jump around, but I think there's time at the end. I'm gonna come back to some certain points. Potential delays in starting hearings, that's a several-fold, right? We have to ask ourselves from a court's point of view, are we doing everything we can to get hearings starting on time? And the answer hopefully is yes. We have links set up, we have files ready, we have calendars ready, we have judges who are ready to go, ready to sign on at 9 a.m. That's our end. The other end, which we see a lot of, is the user's ability to sign on. And what I have seen more often than not, so this is sort of the rule, not the exception, is that people want to sign on, people want to participate. Whether you're pro se, whether you're a litigant, whether you're an attorney, folks want to sign on. The issue sometimes becomes connectivity and the availability to do it. And by the way, no one is immune from this. I'll have pro se litigants who will have a hard time getting on. I'll have attorneys who will have a hard time getting on. And guess who else gets kicked off and has audio trouble in the middle of a trial? The judge. I can't tell you how many times I'm in the middle of like this great comment and everyone's like, Judge, we don't hear you. We have no idea what you're saying. And then I have to sign off. So no one's immune, which means we all have to be considerate and understanding of each other's issues. So that's and then, the one thing I would say before I hand this back over to Sarah is this. From the judicial point of view, this was always the case when we were live pre-pandemic, but it's so much more the case now. Preparation. As judges, I'm a big believer that judges must be an active bench, not a passive bench. We have to be really active. We have to know the cases. We have to know the components of the cases. Because when we were live, we could troubleshoot a lot of things very quickly. Now here, we have to prepare. There's two great statements that I want to, that I always follow that I want to share. The first one is the best preparation for tomorrow is doing the best today. And before anything else, preparation is the key to success. So as a judge, you need to know your case. You need to know all your cases. Do you need a court reporter? Do you need an interpreter? Is there special accommodations that someone knows? There's no more sitting around and just waiting for cases to come to us. We have to be very active and handling them. And what that happens and what that turns out to be when we're so active is success. Success in making sure that our court systems go forward. And sorry, before I hand it off to you, I want to say one more thing, and hopefully Justice Silver would be happy with me when I say this, that our court system functioning never stopped. We slowed down at certain points, but we never stopped. Now we're getting back to the point where we're steadily increasing with great success, and that's because of the preparation we've been doing. Sarah, now it's yours, I promise.
That was wonderful, thank you. The person that's going to speak to Housing Court today is Elizabeth Donahue. She's a partner at Himmelstein, McConnell, Gribben, Donahue, and Joseph. She's also the former vice president of the New York City Bar Association. former chair of the Executive, Judiciary, and Housing Court committees, and has extensive experience in remote proceedings at all levels, and will speak about Housing Court. Take it away.
Thanks, Sarah. Thank you, Judge. I took a lot of notes. Thank you. So yeah, thank you for asking me to speak about virtual proceedings in New York State Court, particularly in Housing Court. As Sarah mentioned, I'm a lawyer in a private firm. I think we need to have a conversation about legal services, pro se litigants in Housing Court, and certain differences. But tonight I'm going to use my time to talk about my experience doing particularly a remote trial through the pandemic. I did a remote trial in what's called an HP action in Housing Court. For those of you who are unfamiliar with that, the HP trial part stands for, it's the housing part of the civil court. It's where tenants or shareholders can ask a court for an order to correct repairs. It has nothing to do with a non-payment action. It has nothing to do with the termination of a tenancy. It's just where there are repairs that are needed and a tenant goes to the judge and says, please order the correction of the repairs. So in my case, I had clients who had been out of possession of their apartment for a number of years, and it was necessary for us to really press forward on the HP action. The case was initially brought in and started, I should say, the trial began in November of 2019 in Manhattan. We continued until February of 2020. At that time, our judge was transferred from Manhattan to Brooklyn. And he took the case with him because the trial had begun and there were already a number of witnesses who had testified. And in Housing Court, you will often get adjourned dates, perhaps a month or 3 weeks from when the last adjourned date was. So the trial was fairly spread out. So in February 2020 and in March, of course, the courts closed. We had a few remote conferences, which were pretty difficult. The remote conferences in general have vastly, greatly improved on Microsoft Teams. But in the summer of 2020, we started to have serious discussions about returning to the trial. At that time, I told the judge that I had a witness, an expert witness from Florida. At that time, the coronavirus rates in Florida were skyrocketing and the cases were coming down in New York. And we knew that the witness would have to quarantine in New York before he could even testify. So the judge signaled that, yes, he would be open to a remote testimony in the trial for this witness who was out of state. I had a number of other witnesses, so we didn't go forward with that witness initially. Our next court date was in Brooklyn in September. It was a live court date. We were moved from 141 Livingston Street to a larger courtroom at 320 J Street, a courtroom where we could socially distance. There was plexiglass around every area, my adversary's area, the witness, and of course the judge. And it was surreal for me because nobody was in the hallway except two court officers. It was difficult to get used to, not just gearing up for a normal battle of a trial, but my glasses were foggy. I mean, I keep my mask on. Everything was just different. We had to shout, is everybody hearing everybody? So we proceeded. Everybody was masked, and one of my witnesses, who was an architect in the field, had manufactured sort of a paintball helmet that he wore in the field. So, I mean, I really couldn't see him, but it turned out he took it off for the testimony, so that went fine. Then I did have to make a motion to take a witness remotely. The application was opposed, but it was ultimately granted by the court. The court found that the remote testimony was the new normal, finding that video conferencing can enhance an ability to observe the demeanor of the witness insofar as a witness in a virtual trial would not have to wear a face covering. We arranged for a big flat screen TV to come into the courtroom that was shared by a number of housing court parts at that time. And so you had to schedule that. Anyway, we were able to bring the screen in and I was able to take the witness remotely while I was in court at 320 J Street. So the first remote witness was sworn in October 2020. He had difficulty logging on. We were delayed by 30 minutes. He had to get his wife to come home from work to get him logged on. Eventually, we got it together. I listened to the tapes after, and I could clearly hear him. The exhibits for that witness, I just don't want to go to, Sarah, give me like a 5-minute warning at 10. The exhibits for that witness were already in the court file. So the judge scanned that exhibit to his email and shared it on his screen. One noticeable problem for me was when the exhibit was shared on the screen, I could not see the witness testifying. So noise and quality is very important in housing court proceedings and all proceedings. But I think we've kind of got some feedback that sometimes it's very hard for the judge to hear the witnesses. The expert I had from Florida who eventually testified, it sounded like he was in like the Daytona 500. It was like, woo, woo. And, finally I had to say to him, what is that noise, Mr. Witness? And he said, they're doing work. Another time, my adversary had an expert witness who it was such a piercing, loud motor kind of noise that we were all saying to him, we can't hear you, we can't hear you. He had to go get his wife in another room and come back and like redo the whole thing. He was testifying into a cell phone. I couldn't see his face. That was really, we just had to keep being flexible. Once we had an evidentiary issue where the witness had to leave, that was before we could do breakout rooms. So he had to go somewhere else in his house, and then his lawyer texted him, and that didn't make me feel so comfortable, that the lawyer was communicating with him in the middle. Not to say that, anything was wrong, but it was just different. At one point, my adversary froze, and I didn't know it because there was a document up on the screen. And I was shocked that I was getting all this wonderful testimony, and I'm wondering, why is he not objecting? Why is he not objecting? And then the judge, about 10 minutes into it, said, do you know he's frozen? I couldn't have seen that. So then he gets back on the screen and he says, move to strike everything. And I'm like, okay. I had to go back and redo the whole part that he said he didn't hear, which was the right thing to do, obviously. Thanks. The difficult thing was exhibits. And I want to talk about that particularly in housing court. There's no right of discovery in housing court. So we don't exchange witness lists. We don't exchange documents in advance. Although I'd say there is a little bit of a nudge toward that. On the Special Commission for the Future of the Housing Court, we had made the recommendation that in a pretrial conference that we share exhibit lists if we can, but there's no requirement for a housing court practitioner to hand over her case to the other side before you begin. So it has been difficult to marshal the exhibits when some housing court judges actually have rules directing people to do that, and some do not because it's free discovery. The other thing I would say about exhibits is that in this case, I had a number of real exhibits, and I actually brought them tonight. They're in my office. If you wanted to see just how big and how unwieldy it is. Like, so here was this like huge big board I had of the building. I had a number of moldy, it was a mold case, moldy shoes and boots. I had a huge, I can't even lift it, rusty pipe. And so the question became, these were already admitted into evidence before we went remote, but the question became, how do I effectively use that in a remote trial? When actually real evidence it's important for an impact to have it in front of the witness, in front of the judge. It's a tactile thing. So anyway, so that was my experience with the trial. It took a lot of, you just had to be agile and cooperation and understanding and patience. And I, credit to everybody who was involved. It was like nothing I'd ever done before in housing court. And the conferences, I would just say, I've done a number of them and they've run smoothly, especially on Microsoft Teams. Okay, that's it.
Thank you. That was very informative. I really wanted to see the pipe, though. You told me you were going to.
I'm gonna pull it out.
Okay.
This is it.
Oh my gosh,
Wow.
that looks like it's fossilized.
I know, it's rusty.
So we're going to move on to family court, and Tuozi Lorna Zen is the supervising attorney in the domestic violence law unit of the New York Legal Assistance Group. Ms. Zen is going to speak about remote proceedings in family court.
Thank you so much, Sarah. Thanks for that introduction. And thank you to my fellow panelists also for participating this evening. And I took very good notes as well. So, COVID kind of struck all of us out from nowhere. And I think for the month of March, I, along with probably the court system, a lot of litigants, lived in a semi-state of denial in thinking that we would go back very soon. And that, this case is just being adjourned till May. I had judges that I had a case the day before my office was shut down, which was March 12th. I appeared in IDV court and my judge said, "Oh, we'll be back after Memorial Day." And she scheduled a hearing for me after Memorial Day. And looking back, that was wildly optimistic and very naive. But that's, the mindset we were at in that first, I want to say, 2 to 3 weeks, possibly even through the end of April. But as it became very clear with schools shutting down, students not coming back from spring break, that this was going to be our new normal. I do want to say that for a system that was, as Judge Ali said, very entrenched and old, I was very happy and surprised with how quickly they were able to pivot and go online. I think there were a lot of kinks that had to be worked out and are still being currently worked out through that late spring, early summer period of time. Personally, I hated Skype for Business and very much enjoy being on Microsoft Teams now. So I was very glad to see that kicked to the curb. And I think that there are a lot of lessons that we have learned and a lot of new systems that we've implemented because of this necessity of appearing virtually because of COVID, that we can move forward and hopefully incorporate even when we fully reopen. I think one of the words Jajali said was supplement, and I think that that's a really important word to focus on. I don't believe any person, be it a litigant, a practitioner or a judge, or even like court officers and clerks that regularly interact with the court system, believe that in-person court should be replaced and done away with completely. But I do think that what we've learned over the last, 9 months now, is that there are ways that it can be supplemented very well, and that it can become very efficient for all parties involved. Particularly, I would say, in the areas of conferences and first appearances or service, return of process cases. I stand with a lot of colleagues that have serious concerns, along with Elizabeth, about having virtual trials. I think hearings is very dependent on what the nature of the hearing might be, but virtual trials is a very difficult beast to navigate, particularly because of the issue of evidence. I personally don't have as many, I would say, non-paper evidence as Elizabeth might deal with, but I can see that being something that comes up frequently in other kinds of proceedings. I do deal sometimes with audio as evidence, and that's a huge problem that, particularly for a trial I have coming up, no one really knows how we're going to deal with that, like in terms of like entering it or admitting it. It's difficult enough sometimes even in person how we deal with, having that video or audio be authenticated beforehand. But it's certainly been something a lot of people have been trying to put forth best practices on, and haven't yet come up with. I will say that most of my clients, and for just a little bit of background, all of my clients are clients that pre-existing COVID had a court case. They already had something on the docket in the courthouse, And in a certain sense, COVID worked to their advantage because of that. Many of my clients were the custodial parents. Many of my clients had temporary orders in place that through various executive orders got automatically extended. Many of my clients had visitation orders they were probably not 100% happy with that ended up being paused because of COVID as well. And so in a way, COVID worked to their advantage and also empowered them because they were able to navigate, the Microsoft Teams, virtual appearances, helping their children be on Zoom school, and they felt very much technologically empowered. That's speaking to a very small cross section of New Yorkers. There are many, many New Yorkers that have been left out of the court system because they don't have appropriate access to technology, because they don't have appropriate language access to the postings or the websites or the various notices that have been going up. And so pro se litigants are very much at a disadvantage. And I think that that's something all of the court systems recognize and are trying to work to address. But in my opinion, it's something we really need to put at the forefront of the issues that we address. And that's something we also have to kind of recognize as practitioners, a certain amount of technological privilege that we enjoy. I've had, this was the year where I walked clients the most through how to set up an email account. I did not think in 2021 I would have to do that. The last time I did that was for my mother back like 10 years ago when she set up her Gmail. But that's, things that are very much at the forefront when we think about access. And family court is really, of most of all of the courts, I would say, the court that is seen as the most egalitarian when it was open. Filing fees are free. That is where you go to get a civil order of protection. That's where you go to file for custody or ask for the court to have your child returned to you or ask for paternity. Nothing costs in money. Unfortunately, half of the cases that family court is supposed to be seeing, they're not hearing. They haven't heard paternity cases. They're not hearing visitation cases or custody cases if there's no emergency. Child support and spousal support cases are kind of being sent into a black hole void, from what I understand. They're accepting them, but nothing's being docketed. And particularly during COVID, when people are at a severe economic disadvantage, the fact that support cases aren't being heard is a serious problem. On the other hand, those very same cases are being heard in Supreme. You can file a custody case in Supreme if you can navigate the system or pay for the filing fee. You can file for a divorce and ask for all the ancillary relief, such as support, or exclusive occupancy or temporary maintenance there as well. So I think that there's a serious discrepancy there that needs to be addressed. And at least our office has started really pivoting to file cases we would normally file in family court now in Supreme, because we really have no other choice. There's only so long you can tell a client, well, we'll wait until the courts reopen, because that only works for so long while their whole life is on pause, particularly when they need economic orders during this time. I do think that, that is something that the family courts are very aware of. I know that they've been working with some Supreme Court judges to try to start hearing visitation and custody cases anew. But the limited proceedings has really put a burden on pro se clients who are either seeking legal services or trying to file themselves, what it is like they should be filing, or, and on another hand, what they feel is an emergency versus what the court feels is an emergency, which has always been a matter of conflict in family court. I will say one of the other things that was very prevalent on a practitioner's level was I personally was very OCD about this, because I'm a very small person who doesn't like to cart all my files to court. And so even before COVID, I was very much on top of scanning everything I got to in court into what is our office's internal F drive. It's our internal remote kind of drive that we can access all of our clients' files. this was not necessarily the best practice from like our office's perspective, or common best practice for our office's perspective. Our office unfortunately also does not have UCMS access, which puts us at a severe disadvantage. But this was something that, like, as the shutdown happened, we realized we needed to start doing very much immediately. The second you got an order, the second you finalized the draft of a motion or finalized a pleading, that needed to not just be in some kind of email, but it needed to be saved in like your office's internal drive, particularly as cases were being transferred. We might have staff turnover. We have cases that we opened and closed in these 9 months that we don't even have a physical file for, but everything is available in our office's drive. So this is something that we've also been working very closely with our own internal office and IT about, to update that in kind of correlation to the virtual process that's been going on in court to match that. I do think that, there's a lot that we've learned. There's a lot, that I think should be carried over to make court more efficient. Many of my clients really like virtual proceedings. For clients who are juggling childcare, jobs, the public transit system, not having to go to court at 9 o'clock for an AM call and wait all day in family court. If you've ever been in family court, you know how that goes, is very great. It's very relieving for them. It's incredibly stressless. Not having to wait until 5 or 6. I don't know if any of you were practicing before the 4:30 cutoff rate was strictly enforced, but sometimes until 7 or 8 o'clock at night, waiting for an order of protection or waiting for a temporary order of visitation. Having that email to them is incredibly stressless and it's a very nice experience. And for those that, I have colleagues on the 18B panels are institutional practitioners in the family courts, having to run from the 6th floor to the 8th floor to this part or that part, that's become it's been really pleasant, or not having to travel from Brooklyn in the morning to Manhattan in the afternoon. I think that there's a lot that has made our work more efficient, but efficiency shouldn't be the ultimate goal. We do have to remember that there are, best practices. And I do stand that in terms of trials, we really should be moving back to in-person trials as soon as possible. I think hearings, as I said, it's a case-by-case determination on what the nature of the relief sought in the hearing might be. But for most of those, when they deal with rights such as, loss of visitation, or exclusions from homes, I do believe that those hearings should also, as to the extent possible, be held in person. The last thing I will say is that I think language access, which I touched upon briefly, is a huge, issue that sadly has not quite been addressed to the extent that we had hoped. I think that comes not just in making sure that notices and information is available to pro se litigants in native languages, but also making that native language posting available through on the grounds organizations, through social service organizations, through platforms that may not be as readily, that might not click as quickly with us. There are lots of different immigrant communities prefer different kinds of messaging platforms that are more easy to use because that's the platform that their home country or their area of origin is become familiar with. And we need to also recognize that that is part of the access issue, that it's not just language, but it's how these notices are getting to litigants. Because I personally have walked to Supreme Court to have a notice posted on the front door. Yes, that notice was in English and Spanish and about 2 other languages, but I walked to Supreme Court to find that notice. And I had already taken a lot of time out of my day to have that notice, be waiting for me after I spent so much time traveling. So I think that updating the website is very important, but also making sure that social service organizations are kept up to date as to changes in the court systems, and updates with the court system is very important too.
Thank you
Thank
so
you, Sarah.
much. I'm sure we'll be back to you, particularly about your clients and how they are dealing with the technology divide. Um, Judge Ali, I'm going to move back to you and for your at least 6 months of criminal trial experience as presiding judge there. Please continue and speak about criminal court.
Okay, thank you, Sarah. And thank you to both Elizabeth again and Lorna. I learned a lot. And before I change hats, right now, if you're all looking at me, I'm wearing a civil court hat. Before I take it off and put on my criminal court hat, I neglected to thank my committee chair, Sidney Cherubin, of the Civil Court Committee of the City Bar. And again, I don't want to start controversy. Our committee is better than yours, but Civil Court Committee is pretty awesome. So thank you, Sidney. And I will take off the hat now and put on another hat. Elizabeth, I love your demonstrative evidence. I mean, who doesn't like a rusty pipe on a Zoom call, right? But if you notice Lorna's reaction, judges, we don't miss that point. You show that and you still get that flavor. Although I do, I should tell everyone, a little bit about my background. For 18 years, I roamed the hallways of family court, criminal court, civil court, Supreme as an 18B attorney, as an ACS lawyer, as a corporation counsel. So I am in a way awed by what we're doing because for 18 years, I only know one way. And the inferior way was a telephone call into a courtroom where you felt like I wasn't participating. Now, virtually everyone is participating. And before I get to the criminal court part, just so that we get rid of this sort of like thought, the judiciary is also interested in making sure this works absolutely well for everyone's experience, the lawyers, the litigants, the attorneys, and really for justice, right? And before we spend too much time wondering, boy, are the poor pro se litigants going to handle this? I got to tell you, spend a little time observing court. You'll see the pro se litigants have a better handle on virtual court than the judges and some of the lawyers, right? I'm going to reference that infamous Zoom "I'm not a cat" incident. That's between two lawyers and a judge. There was no pro se litigant involved in that. The pro se litigant probably got it right and signed on correctly. And the real hero of that story was the judge. Boy, did that judge keep a calm demeanor. I don't know what I would have done. All right, now putting on my criminal court hat. What's amazing is that criminal court was always heavy paper intensive. I mean, the packets were handed to you when you're in arraignment. You had a moment at that point to flip through the complaints, the rap sheets, to look at everything. And then if you're being asked to set bail, come up with a number at that point. Or if you're supervisor release or ROR, very paper intensive. And I learned that every new judge assigned to criminal court has the same question and they're told the same answer. Why can't this be digital? And the answer is always, oh, knock it off, just arraign the case, judge. Come on, everyone comes in here, you're gonna go and, this is the way we've done things. And the key is this, just because we've done it one way doesn't mean another way is not available. I do agree with everyone here that there is room to keep some of what we're doing now virtually, but also room to go back to what we're doing. Maybe trials in person, maybe conferences. In civil court, no fault's the most perfect sort of specialty to have all virtual. They're all lawyers. The hearings could be done virtually. So it was a very interesting feeling in criminal court. So I started in January of 19. I was in person. I sat in a domestic violence part where I was doing 150 cases a day in person. Imagine the papers that were going back and forth, courtrooms filled with people. It was like a pandemic nightmare back in 19. Imagine that shoulder to shoulder sitting there and we were moving things around. And then we flipped it over real quickly in March of 2020 and we went remote and we had to deal with it. And I was doing a tremendous amount of, remember I said courts never closed, we just reduced functioning. We were all doing arraignments at one point. And I found myself, because my son was in school, I took a lot of night court shifts. So here I was at 11 p.m. at midnight, sitting at my dining room table, arraigning someone. Where a couple of hours ago I was having dinner, I'm now, looking at someone's rap sheet to determine whether or not I'm setting bail. And here's something I want everyone to know, and I think my colleagues on the bench will know this. As much as I ensured and made sure that the preservation of the accused was intact, including their lawyer, the court staff insisted and made sure that things went smoothly. So our clerks, our court officers, if there was a hint of an audio issue, we would stop. This wasn't about drive-through service where we wanted to do things fast and move things along quickly. It was if there was any hint, because we were in this forum, that someone couldn't hear or something wasn't happening correctly, we will put a pause to it and try to fix it. I was very impressed with that. What that meant was very late nights. Night court went to 1 a.m., but it wasn't 1 a.m. It was until business was done. And there's routinely times where I signed off at 3 a.m., 4 a.m., but it felt fine because we knew that justice was being done. So in criminal court, the arraignments worked, it worked well. There were separate areas for individuals to be in a booth. They heard me. The judges had had their own individual script, but judges went through a checklist to make sure the individual could hear us, understood what was happening, had an opportunity to speak to their lawyer. If you listen to what happened, you would think the judges are really concerned with making sure everyone understood the process. And the reality is that we wanted to make sure that everyone understood the process. Something else that I thought was interesting, now this goes across housing, civil, family, and criminal, is that the judges, we learn from the practitioners as well. Like, I want to know from everyone what is happening on your end to help better our system. As supervising judge, I routinely speak to litigants, pro se litigants. I speak to lawyers. I want to know about their experiences, because for every comment, you're going to get a good actionable plan. Because again, there's no utility asking your next door neighbor at the office, hey, how did you guys do this in 2018? It didn't exist. We're all learning this together. When we moved past arraignments and started to reopen certain functionings in criminal court, the same issue became present as we're dealing with now. How do we contact individuals who, before the pandemic, maybe capturing email addresses wasn't the most pressing matter because everyone had got an adjourned slip and you knew to come back at a certain date. So in criminal court, you had defense providers, institutional providers who needed to get a hold of their clients. So there was a need to look at inventory and try to move things along, but always with the watchful eye of, are we shortcutting and hampering someone's rights? And if we even get close to that line, forget about being on the line, even if we got close to that line, we reeled it back and said, wait a second, I'd rather wait than default someone or enter a disposition that was not correct. That's how cautious we were. And then you started again with the all-purpose parts, with conference parts. The attorneys, through reps and times, the attorneys got an idea of how to get a hold of their clients, and their clients were able to sign on. I know judges, including myself, that we just wanted the individual there. It wasn't form over substance. It was substance until it was needed to be form over substance when we're doing with trials. So when we had motion parts, again, as long as I was satisfied that this person had adequate legal representation and knew what they're doing, we moved forward. And then the same thing with bench trials. As long as parties are aware of their rights and waive their rights to bench trials, then that's something the court can effectively feel good about proceeding. Now, when you have things with two attorneys, it's a lot easier to proceed on those. Obviously, in criminal court and family courthouse, that's just the way it is. As long as you have two attorneys, it's go time. Like we're like putting on the calendar. If someone raises a concern that the virtual way is not working effectively for them and their clients, we have to take a hard look at that. What is happening with that? And this happened in criminal court as well. I was responsible for moving through our desk appearance ticket inventory, and we had thousands at one point because the arrests weren't stopping, but we just weren't going through those. So we needed to know how many cases we can get through, and through partnership. And I use that word carefully because it was partnership with the DA's office, the defense providers, and the court. The idea was to get these cases back moving, to justice to start, those wheels to turn again. What can we do to effectively do that? And there was a meeting of the mind. There wasn't like this headbutting where people were trying to jockey for their own positions. Things happened. So virtual bench trials were happening. I think everyone knows what's going on with jury trials. You just have to follow the chief judge's daily reports, all of the newspapers. I'm not going to spend too much time on that. But you don't want to ever sacrifice someone's health and safety, because at the end of the day, it's never really worth it, right? If someone is ill and God forbid dies, we don't want that. So there is room to continue with what we're doing. And in criminal court, I mean, talk about a system that had to do a complete turnaround from all paper-based to virtual. I was very impressed with what was happening. And I think Administrative Judge Amaker needs a lot of credit for that, as well as Judge Ruiz in family court. As an aside, my wife is a family court judge in Brooklyn, and she was presiding on one of the very first virtual appearances in family court. Family court's been going full steam ahead. So in civil court, I actually draw inspiration from what my wife is doing in family court. And that's something good for all of us to know. I mean, I'm looking at the list of participants. We all span different courts. We can all learn from each other. Maybe there's a time for us to come together for a jam session. I'll send out a Teams link for all of us to talk and share, because that's what we need to do. We need to learn from each other. And if there was ever a time to do it, now is the time. All right, Sarah, it shows back to you.
I would like, thank you very much, Judge. I would like for the people that are speaking on the housing court and family and criminal court venues to speak very briefly on the due process of rights of the people that appear before them in remote proceedings. Do you think that they are, because of the consequences of such actions being so severe, do you think that they are appropriate venues for that sort of proceeding? I'm going to start with you, Elizabeth.
Yeah, I mean, Sarah, family court, housing court, you're talking about incredible risk. You're talking about people losing their homes. And the question is, if there's a great technological divide, and I think that the Housing Court Committee, your committee, has reported on this. On the one hand, you have lawyers who are sophisticated, and then you have a lot of pro se tenants. And what if they don't have the technology? What if there is an eviction action? They should not end up homeless. And so, this is such an important point, and a lot of help is needed to look to how they can participate. And I think, we're very concerned about their due process rights participating remotely. It's an understatement.
Lorna?
I think that there's a big due process issue when it comes to notice, when it comes to being able to provide proper notice for hearings, proper notice for returns of processes and for trials. Having done a few custody trials now, I'm still in mid-trial on them. I believe I had one that had a decision come down. I don't find the trial experience to be quite honest, that much different than the in-court experience, because it's mostly testimonial evidence that we're dealing with when it comes to custody. It's here and there might be some documentary evidence, such as medical records or forensic report. These are usually shared well in advance. Here and there, that might be an expert as well, but it's still, again, very much testimonial evidence. And it's a case that's been proceeding for some time with a lot of temporary orders that's been going on in the meantime, in terms of temporary orders of custody, but usually visitation. My main concern when it comes to due process for issues of particularly custody or orders of protection is that because the family courts are partially closed, or because there's not good information being sent out to the public about what can be filed, that not filing something or not getting something in court may be held against a parent. I have clients who may not be the custodial parents right now, but and there's conflict with visitation or there's conflict with custody, but it doesn't rise to the level that I think the court might be willing to take that visitation case or that custody case. And so, when we know in the family court statutes, when the status quo is a big consideration as to what is the best interest of the child, I think there will be a lot of discussion as to whether the COVID status quo should be counted, how that should be factored in. particularly if the courts have been closed, right? Is it fair that a parent is not getting joint residential custody because for the last, 9 months, he or she has not been able to really visit the child, either maybe because the child has a special medical condition, or maybe because a parent works in a medical profession, or because it's just not tenable right now because there might be other concerns. Like, how is that factored in? And so I think that that's certainly something as the courts reopen, we're going to see a lot of as to how, judges and referees view that period of time, and how that may be factored. I think that kind of goes to due process a little bit, but much more to the best interest standards in, in a kind of relationship with the fact that due process was not allowed during this period because such cases were not accepted. Similarly, the issue of like child support as to like how far back are we going to calculate arrears right now, or how far back are we going to consider supports orders should have been entered when these cases haven't been docketed for almost a year now. So I think in that sense, there is a definite due process concern because the courts have not been fully open.
I just also want to mention, there's an eviction moratorium right now. And when that eviction moratorium is lifted and the cases start to come through court, and you have a tenant who doesn't have access to technology trying to go to court to bring an order to show cause, what will that look like? Because if they don't have access, I'm just not sure what that's going to be. But obviously, this is the big thing that's on all of our minds. What happens when the eviction moratorium is lifted and these cases start to go into court.
Judge, a moment for the due process rights of criminal defendants.
Sure. And I'll add a little something on civil as well, because I think it's very important. With criminal defendants, the right for due process, and due process is the opportunity to be heard, to have your case fairly tried. The judges and the judiciary is there with you. We're not against or aside. We are an active participant. So if someone doesn't appear, if there's difficulty with connecting, we're right there with you and trying to figure out how can we get that happen. The upside to criminal court is that you have institutional providers that do a very good job with getting hold of the litigants. The hiccup was, and it was unanticipated for everyone, is that time when things were slowed down and in trying to capture everyone's data. But in criminal court, you'll find that judges are very cautious when we are proceeding with cases that, and we rely heavily on the attorneys to tell us what's happening. Where if an attorney indicates that their client's having a hard time connecting or appearing, we're not defaulting, we're not moving forward. It's certainly unconscionable to do that. But it raises a lot of other issues that just might bring the case right back. Every day I have a talk with my judges about certain things, and there's this desire, and I was just talking, our administrative judge was just talking to us about this. There's this desire to get work done. Like we want to do work, but at what cost? And that's the question we have to ask ourselves, because we cannot sacrifice. We have to somehow take a moment to think at what cost. And if the cost is due process, then the answer is we don't do that. We hold off and we preserve the rights. In civil court, we are actively, when I say active, we are mailing solicitations to folks to contact us about their cases. If they haven't had a case that's been heard yet, we send out notices. We're like, contact us. We want to help get these cases on the calendar. Maybe we didn't have your right information, but we sent out one round of notices for small claims matters. We sent out another round giving other options how to contact us. So it's, not only are our doors open, we want to make sure that everyone comes through. With pro se litigants, judges, and I'm looking at the list of judges here, and I see a lot of judges on here from civil. I've watched judges, they go through such a careful checklist to make sure everyone is heard. Heard meaning giving individuals the proper time to speak, if they want to submit certain documents, and walking them through it, not to prejudice the other side, but both sides, whether you're represented or not, have never used this sort of platform. So everyone deserves a little bit of education on this. So this is the right time, believe it or not, to preserve all those due process rights, because we're all doing it again together.
I'm going to move to the Q&A questions because there are two questions that that blend very well together. The first question, which says, does anyone know when virtual hearings will take place in landlord and tenant cases when both sides are represented by attorneys? And Judge Kanataro's response, which says, it looks like limited in-person trials will be back soon. What are the key factors in determining which trials can be conducted virtually versus those that must be conducted in person? Does anyone care to answer?
Sure. So if my boss is saying we're going to do it limited in person, so let's do it. You know, that again talks about knowing your case, right? Being that active judge who knows your case and conferencing. Just very recently, we received the judiciary, and I believe the public as well, this virtual bench book that was generated and through a collaboration, but by Administrative Judge St. George out in Long Island, that talked about best practices for virtual bench trials. You know, the attorneys really are the ones to help lead. They know their cases, they know their evidence. They will tell us, look, this is a perfect, you know, and then you will look at it and say, you know, this looks like a bench trial to me. You know, what do you think? And while there isn't the same mandate as it is in criminal court to have that waiver, we want the consent, we want the waiver, and the attorneys also want to proceed virtually on the bench trial. So the first thing I would say in terms of a criteria is I would look at the evidence. I would look at what needs to be the availability of witnesses. And again, the attorneys will tell you whether their witnesses are available. They have the technology for it. And there are times when individuals cannot simply appear, and maybe that's the time. Something that we do very cool in New York County Civil Court is that, you know, no, this is access to justice and the people's court. While we try to keep folks safe and maybe not populating the courthouse, we will not stop anyone. So if someone comes in who's trying to say vacate a default judgment and needs to come in, there's a courtroom outfitted with safety precautions that person can come in. But for safety purposes, maybe the other side are appearing by teams, maybe the judges in chambers, maybe we're doing it FTR. So we have systems in place. No one's ever shortchanged and no one's ever told no. We have systems in place. Maybe that's the same thing with the bench trials. If we can have everything in place, you know, the attorneys will tell you their witnesses rather testify from Long Island than come down to New York City to have their trial. So I think we need to have a checklist of what can be done virtually, what could be done in person, and really what needs to be done in person.
Sarah, you are muted.
Pardon me. Speaking of a checklist, the Chief Judge distributed a virtual bench trial protocols and procedures book that I'm aware that the judges are calling the bench book last week. And having read it, I wasn't all that sure that it applied very specifically to housing court. I imagine that that it may not apply particularly to family court either. I'm not quite sure about the criminal court, but what I would suggest is that it presumed a certain amount of affluence of the litigants and availability of technological facilities that we may not have in our courts. Can anyone speak to that?
Sure, I was happy to read it. I think that, you know, it makes good points, but for housing court practitioners, so for example, you know, to share email addresses, to get all this information up front, witness lists, et cetera, going back to what I said earlier, where we don't do pretrial discovery in housing court. So a lot of the suggestions, you know, just don't apply to the housing court because of the discovery, you know, particulars.
Liz, there's a specific question for you here that says, how has the discovery and disclosure process and practice changed? And do the court's protocols for virtual trials require disclosure of witnesses prior to trials and require parties to seek to agree on all exhibits prior to trial at the pretrial conference?
I don't think a judge has authority to require it. I know judges are doing it. I know a number of them who I respect very much have rules, but I don't think it is you know, I'm not sure what it's authorized by. And so I've been in a number of trials where, you know, the relationship with opposing counsel is not collegial. It's not, let's share our lists, let's share our reports ahead of time. And that's just the way those trials go sometimes. So I think when you have a good relationship with opposing counsel, more people are doing this. And I think that everybody benefits when it can happen. I've heard judges say, by the time you sit down and start the trial, because everyone has exchanged PDFs with exhibits, and sometimes there's a PDF with agreed upon exhibits and a PDF with not agreed upon exhibits, or everybody agrees everything's coming in and then you can argue about the relevance. That makes for a much smoother and much faster trial. But again, that you could just as easily go into a trial and have no idea what the other side is going to produce. And, you know, you're just stuck with in the moment finding out, and that's what it is.
You know, Sarah, the document that I referenced, one, I think it's titled Virtual Bench Trial, you know, Virtual Bench Trial Bench Book. But within, it does acknowledge that it does not include or contemplate every circumstance or every court, and that individual courts should fashion their own. And that is what we're doing in New York County Civil Court, because looking at those protocols, you know, it just doesn't fit us also. But what it does, and I think this is a utility, and this is something that in Supreme Court we have when we have part rules, or it offers guidance. It offers guidance to attorneys. It offers guidance to litigants. It also offers expectations. And that way, you know, one of the things that goes counter to due process is not knowing what will happen, not knowing what was needed. This is an excellent step forward because it addresses those points. Does it hit every matrix? No. I mean, not every court is very different, and you have to operate that way. But this is an excellent start to hitting. You know, while we can't control it all, I think litigants, both pro se attorneys, everyone, deserve the right to know what's happening and an expectation of what will happen for going forward. So what we're doing is we're taking this here in Manhattan, we're taking this document and crafting our own, because that's something that the public should know, that when you step foot in New York County Civil Court, here's what you're going to expect. And that's a win for us.
Sarah, I agree. So our office practices in the matrimonial parts in Supreme as well. And as you know, a lot of those issues overlap. As I had said, you can litigate custody in Supreme just as you can litigate custody in family court, and the same for child support. And so there is this, you know, kind of this trickle now that the part rules that have the discovery protocols that, you know, are pretty much regulated in matrimonial parts. You have to have your preliminary conference orders, you have to have an exchange of discovery, you know, you have to have compliance conference, that these are like, in a way, while I acknowledge with Elizabeth, the authority to kind of order that is questionable, but that practice is sort of like, we're seeing that a lot more sometimes in family court now, not necessarily because, you know, discovery should always be exchanged, but it's also sometimes just to push the practitioners to get their case in order, right? Like to send out their subpoenas when they're supposed to send out their subpoenas, to contemplate who they're going to be putting on trial. Because I've had so many cases over the years, particularly in family court, when, oh, I haven't, you know, we can't go to trial. I haven't gotten these records yet. Why weren't these records subpoenaed at the beginning of the case when you knew they needed to be subpoenaed at the beginning of the case, right? Oh, I can't, you know, I can't go forward on this trial because my witness is not available. Like, why didn't you come in before we selected trial dates with your witness's availability? So I think it's really, in a way, kind of tightening up, helping to tighten up scheduling as well, as opposed to, you know, a true exchange of discovery so that there's no surprise. I think that's one factor, but the other is to just make sure that we're more prepared on our cases.
Sarah, can I just say one more thing? You may, I don't know if it's been your experience in housing court, but, you know, post the special commission, as I referenced earlier, you would go out to part X, which was the trial assignment part, and then you went to a pretrial conference another day. And there were forms that we had to fill out. And I'll just read what the forms after the commission required. Okay. It was to the extent relevant in the case, the pretrial conference should finalize the time frame for the trial, the number of witnesses, the dates for submission of trial memoranda, legal and factual issues in dispute, identification of documents and subpoenaed material to be used at trial, pre-marking of exhibits, and to the extent possible, a resolution. And when we would go to that part and do that, it was helpful, but it was not the same as saying, okay, here's exhibit A, B, C, D, 2 days before trial.
There are two questions regarding pro se litigants, particularly, I think for you, Judge, are pro se consumer debt cases being heard in civil court? If so, how do you get email addresses of pro se defendants? Any problems dealing with pro se defendants virtually?
Consumer debt cases are being heard in New York County Civil Court and the Civil Court in general. Sarah, and for the panel and for everyone else, I want to say I'm speaking for Civil Court and Criminal Court. So I don't want to neglect my Criminal Court colleagues and friends on the line. And I will say that I'm happy to be in Civil Court. And as the old saying goes, if you can make it in Criminal Court, you can make it anywhere. So hopefully that makes my friends in Criminal Court happy that I said that. And I do mean it, by the way. My time in Criminal Court helped set me up for this. In terms of consumer debt cases, we are proceeding with consumer debt cases. We see those cases in one of two ways. We see them where a litigant, a defendant, brings in an emergency action to vacate a default, and that happens quite often, right? So when that comes in, that individual comes in, it's easy to capture their information because they're before us. So we have that information, email address is done. The trickier point is when we have an existing case where we might not have had an email address. So that's where the solicitation goes out to get information to come back. Sometimes the plaintiff will have information. Now, this is the interesting thing about those cases. We docket those cases only when we have only when we have two email addresses. Even when there's an assistant that we docket those cases. If we don't have a defendant's information, there's no value to putting this case on the docket because I'm not going to default someone who very well is out there interested in proceeding their case, but there's this divide between being able to come in. So, and what's interesting about it is that the plaintiffs understand this, that you have these attorneys who understand this dynamic, and there's no pushback with the court. It's not like they're throwing their hands in the air and saying, why aren't you defaulting it? Why aren't you putting them out? They get that there's this right, this due process right that we're not going to budge on at the court level. So help us get information. And sure enough, many plaintiffs will say, Judge, for our files, we have email addresses. Can we provide that? And so there are ways that we get this information. So no case, especially in New York County Civil Court, no case lands on the docket without there being at least information that the defendant will appear and a link that goes out. And when you send a link, the individuals, and I'm sure everyone knows this, but when you send a link and the individuals get it, they accept it. So you have a good link. If it's just no response, then you start to question whether or not the email is good. So there's ways for us to, there's little tricks that we have. And once the individuals appear, again, there's a lot of concerns about pro se cases and consumer debt cases. I invite everyone to take a look at and maybe sit in one of the consumer debt parts, because the only thing and this is something I tell my judges, the only thing you can take away from an individual being pro se is the fact that they don't have a lawyer. You take nothing else away from that. You don't read anything into it. They are no less sophisticated. They are no less able to handle. I had a pro se litigant the other day who was quoting rules of evidence and was doing a good job. And I said to counsel, you're gonna get your hands full because this guy knows what he's doing. So I've had no issues with it. I've had individuals who were frustrated, and that's just as a judge, you have to deal with individuals as they come with you. But in terms of just general problems, no, nothing more than I would have seen in person. And then I certainly don't, and from my personal point of view, and when I measure, I don't see a marked difference between an attorney and a pro se litigant. There isn't attorneys have better Wi-Fi. If your Wi-Fi is not good, it goes across the board, or people have a hard time connecting, it goes across the board. So I don't see a real difference.
I'm going to use your answer to that question to address a new question. It says, this question regards open courtrooms. Can anyone in the panel address the extent to which persons not connected to the case may observe the proceedings? My agency hired a number of new attorneys, for example, who want to observe proceedings in order to learn the practice. And I'm going to add here, and supervisors really want to sit in on these proceedings and supervise their staff attorneys. Some of our clients want family members or advocates from the community to participate. Community organizers have expressed concerns that proceedings in family court are closed to public scrutiny, though that is not technically the case. So I think what we're asking for is information on the openness of court proceedings in all of your forums.
Sarah, I think this is something we talked about in our little kind of brainstorming session that I think is one of the biggest losses of moving to virtual court. Our office had to, we hired some new attorneys, straight out of law school, attorneys that have never seen the inside of the courtroom and to date still have not seen the inside of a courtroom. And, you know, we had a full intern class over the summer as well, which prior to hiring them, court accompaniment was like a huge factor of why they were attracted to our internship. And I think sadly, like that has been one of the biggest losses in this virtual experience is I don't get to, you know, introduce a new attorney from my office to a judge in family court. That attorney in turn doesn't get to sit in that part, you know, and see a few cases called before his or her case is called to see what the judge is like, what their demeanor might be, how they might handle things. Maybe sometimes to see the judge yell at someone so they know it's not personal and that, you know, when they go off the record, things are, you know, cordial and collegial again.
Judges don't yell now. No judge has ever yelled.
um, just talked sternly, I know. As you know, I think as we've become a little more open, particularly as we've moved to Microsoft Teams, I've been very vocal about making that request of judges. I let them know in advance, perhaps in email when I confirm like the link or some information with the court attorney that I have, you know, for instance, I'll have an intern sit in or I have a paralegal sit in. Sometimes it's to take notes. Sometimes it's just to observe the case. Most of the judges, I will say, if making that request are very welcoming of that. They do ask that that person not put their video on. So they're just kind of like, they can see, but the judge can't see them. So it's not a distraction as to all of the faces. But I haven't really done like more than one participant. And usually it's a person from the office. I will say I don't know how it will be interpreted when it comes to having an advocate on or when it comes to having a family member participate either. So I'm not sure how the court may take that, particularly also if there's concerns that that person may later be called as a witness in the proceeding, even though technically like up until the hearing or the trial, they are allowed to sit in on the proceedings. But I think as, you know, this is something we're just finalizing our interns for this summer and we're thinking of hiring new staff. And we have a lot of volunteer attorneys actually like jumping on as well who want to see how this virtual proceedings go forward. It's certainly something that we've been more and more vocal about having like a second seat, you know, having a supervisor available. I think it just needs to be made clear to the judge who is speaking and what the person's role is. So there's no confusion as to who the advocate is going to be.
Well, I know in Elizabeth, I'm not sure if you have an answer, but I'll tell you that I know in family court and criminal court there are public viewing stations in the courthouses for the public to observe. The rules haven't changed. We're still a public court. It just takes another step, right? I've had and I speak for New York County Civil Court. I've had members of the press observe proceedings. I've had individuals who've brought support members to observe proceedings. It goes back to that point of preparation. And here's a concept that I learned in criminal court, which is fronting issues, always front issues. You know, and this goes back to the attorneys. You know, as judges, I observed, and you know, the term is advancing. I used to advance all the time. I sat in the back of courtrooms. That's how you learn. You know, you learn the buzzwords of judges or the words you don't want to use. That's how you learn. But now we're not in a a difficult position. We're just in a different position. What I would say is that, and I hope I don't get in trouble with supervising judges, but reach out to a supervising judge and make that a claim that you have attorneys who want to look. I personally don't think I can think of a situation where I would say no. And in fact, I would offer to introduce myself to the attorneys so that they know, again, that word expectation. Also in Microsoft Teams, there is a way to have individuals observe proceedings under a hard mute. That way their video is not on, their audio is not on, but they can observe, right? Because nothing we do, should go to denigrate the process, the legal process. We cannot do things to disrespect our process, but and individuals should observe. In fact, I've said this many times, individuals should observe, certainly attorneys. It's just the details that need to be worked out, right? So there is a way for attorneys to observe. I've had students who observed my class, my own students, who observed court process. And if there's a member of the public that wants to, there is a way also. We just have to get links to them. In the law journal, the courts will publish when cases are on, and numbers and ways to contact for a link. I understand not everyone has a subscription to the law journal, but as the court system, we're also trying to figure out which ways can we get this information out. So my ask of all of you on this line is, if you have a very creative way of getting this information out, contact us, contact me. I'll be the point person on it, so that you're not inundating, Judge Cantero's inbox with emails. Contact me, tell me, hey Judge, have you ever thought about this? And the answer probably was, no, I didn't think of this, but it sounds fantastic. There's no upside for us to close these proceedings, unless of course there's a reason to close them, but that's just governed by law. But if it should be open, then it's open. We just got to figure out the details.
I agree, Judge. Court is open. It's open to the public. I'm sorry. I had a funny experience though. I was about to get on a conference. I knew my client would be on, and then my client said, oh, by the way, all the tenants in this large tenants association want to get on. And I thought, whoa, I should definitely give the judge a heads up about that, because the judge is not expecting many, many, many more people. So anyway, it just sort of surprised me that this was even an option. Of course, they could have come into court and sat in and watched, and no issue.
Right. Part of the judge's role is also for proper courtroom management. And when I say judges need to be active, they need to be active. You need to know who's in your courtroom, if there's a security issue, if there's a possible disruption issue, or just knowing, right? So maybe the surprise was that in the virtual setting, there's more than one person who wants to be in there. Sometimes you can't get the folks you need in the courtroom, much less anyone else who wants to observe. But I think it's a good point. I think it's a valid point, and it's one that's worth looking into a creative solution for.
We have reached the quickfire round. 5 minutes to go. Super short responses. There has been discussion of setting up facilities with equipment and connectivity around the city where pro se litigants could go for virtual proceedings. Is this being done? Yes or no?
Yes.
Does either of you have any experience with any of those thus far?
Not yet. I don't think they're live yet, unless maybe they're in some sort of beta testing phase. But we have not heard of that being live yet.
Okay, we look forward to that. Are judges being required to publish their rules for remote trials? Do you believe that the failure to impose that requirement, I guess they're not, will make it virtually impossible to prepare for a remote trial?
No, I don't think it's impossible to prepare for a remote trial without the rules. I think you can prepare for a remote trial just without the judge's rules. The judge will tell you what the judge wants sooner or later.
That's a tough question because presumably there had been a conference, right? If you're only relying on part rules that you're finding online, then I think we've missed, there's several other concerns that we have to talk about. But with our judges, we have very extensive, very detailed pre-trial conferences. Again, going to expectations and what's expected, there's no surprises in New York County. It's all about the law. It's all about the facts. We don't surprise anyone. The goal is to have them publish sort of like a belt and suspenders that, more information, but folks know.
Judge, what happens if someone doesn't follow them?
That's when Lorna comes in and we yell.
Talk
Speak
sternly, I thought.
Talk sternly. I'm sorry. Talk sternly. I sit up straight and I use my grown-up voice.
And finally, the Dean of CUNY Law School asks, is anyone collecting data from court-involved persons about their experiences with remote proceedings? Do some of them appreciate the convenience of not having to travel to court? How many of them find the technical issues to be barriers? Do they feel more or less heard remotely?
Great question. I don't know who's collecting data, but I'm sincerely hope someone is. There's surprises in this.
I'd
I
be
know
very interested to see the data as well.
I know our Deputy Chief Administrative Judge, Judge Mendelson, who has access to justice, I believe, is collecting data or very interested in collecting that data. So we have a point person. And I have to say, after 12 years of a public defender representing individuals, the one thing that I know from a client is that they don't want to waste a day in court, right? The court doesn't want to waste your time. Every court date matters. Every adjournment matters. It used to break my heart when someone would take a day off of work just to have something not happen. So the virtual appearance definitely has its upside.
One last question for all of you. Through your experiences, have you found one platform versus another works better than the other, i.e. Zoom versus Microsoft Teams? Also, have you found, if you know, litigants or lawyers using VPNs have less legal issues versus not using VPNs?
Ooh.
Microsoft Teams is far better in my experience. I don't know about VPNs.
I agree that Microsoft Teams is better for court. I prefer Zoom for like trainings and presentations, just because you can take polls, which I very much like, and I think that's a nice factor. I'm not sure how the VPNs would play into it, other than I don't believe the court is collecting IP information in terms of where people are logging in from. And if that's just the concern of keeping your IP address confidential, that's the only reason I kind of can imagine a VPN is being used.
I concur with Elizabeth and Lorna.
We are at an end to our program. Please attend the next program, which involves, hang on, let me get the actual title of the program. The next trial concerns complex litigation courts and federal courts. Thank you very much.
Thank you, Sarah.
Sarah, thank you, Elizabeth.
Everybody, thanks you guys.
Have a good night.
You too.